Okay, probate and fights among siblings is unfortunately all too common, right? We see it all the time. And so what I wanted to talk about in this video is how to essentially, you can't, make your kids necessarily happy with your decisions, but what can you do to best prepare, your kids so that there's no fighting after you pass away? And so this assumes that you're going to probate, right? Now, I advise the majority, probably all of my clients, that they want to avoid probate, right? It's a court process. It takes a long time. It costs a lot of money. It's public. It leaves a lot more room for fighting, in my opinion, and from my experience based on what I've seen, than doing other sort of planning, like setting up a trust. But let's say that for whatever reason, you've decided or you've been advised that a trust is not the best option for you, or you just want a quote unquote simple will. You just want something written down. And so now your family, your kids are going to have to go to probate. How can you set them up so that they don't fight, or at least, you give them the best opportunity not to fight? Well, when you have a will, you are going to name somebody as your executor, or what we might call your personal representative or your administrator, somebody who's going to handle all of your affairs after you pass away. This person's going to go to court, probably choose the probate attorney, sign the legal documents, ask the court to make the distributions, control the assets, all that sort of stuff. So one of the things you might consider, if you have more than one child, is choose a third party, right? Choose a neutral person. If you got 3 kids, choose somebody else, right? Don't choose a child. Now, you want to make sure that the person you choose complies with your state's requirements. For example, in Florida, if they're not related to you, they have to be a resident of the state of Florida. So you can't choose a friend if they're a resident of New York, but your estate is going through probate in Florida. So just check your state requirements, but that might be an option, is you just choose a neutral person. Something else you might want to consider is discuss your estate plan with your children. I know this is often a difficult conversation, not a conversation that most people want to have with their children. But if you just have an open and honest conversation and say, look, this is what my plan looks like. This is the person who's going to be in charge. This is what I want to happen with my stuff. It comes as no surprise to your kids when you pass away. So that might be an option. Another thing you might want to consider is getting a full physical and maybe a mental neurological analysis, something to the effect where your kids or child or the person you think who might try to contest things can't come back and say, yeah, but mom, dad, they didn't have capacity, right? They had Alzheimer's, they had dementia. That's one of the arguments a lot of times people will make if they don't think it's a valid will, is they'll say, yeah, but mom didn't have capacity when she did that will. So we might, especially if we have older clients, and they might seem a little bit slower, right? As you just slow down, nothing wrong with them. They're just slower as they get into, their late 80s, 90s, something like that. If they want to create a will, or if they want to change a will, I'm probably going to advise, listen, I've spoken with you. You seem fine to me. But, you got a couple kids, and one of them might say, they changed their will when they were 92. I don't think mom had capacity. Just go see your doctor. Get a letter from him or her saying, yep, we did a full workup. They have capacity. They know what they're doing. They're fine. So that might be something that you consider as well. Another thing that you could do, especially when it comes to burial and cremation wishes, is have that written down, right? Let your kids know what you want, because a lot of times I see this where there's a lot of fighting. One of the kids wants to do cremation, the other one wants to do a burial, one of them wants to do it at a certain church, one of them wants to do it at a funeral home, whatever the case may be, and they just can't agree on what to do, and it just becomes a very difficult situation. One other thing I might recommend is, and this is not necessarily just self-serving because, I have a estate planning law firm, but I just think do-it-yourself documents tend to do a disservice to the client, right? They might be fine. The problem is, though, you will not know if your documents work or don't work until you pass away, because you don't use them while you're alive, right? So I always am going to suggest, spend a little, this is an important thing. You only die one time, right? You don't want to mess up what's going to happen. And so, if you can afford it, you might want to spend a little bit of extra money, have a professional who does this day in and day out, review the documents, draft the documents, and really make sure that your wishes are carried out. So those are just a couple of suggestions that I would make if you're going to choose the probate route. Again, I would advise pretty much all of my clients probate's a bad idea. Maybe you live in a state where it's really simple. I practice in Florida and in Tennessee, and it's not all that simple. So it just might be something that you want to consider. Unfortunately, you can't stop your kids from fighting once you're gone, but you can at least set them up so that there's a lot less risk that they will fight.